Hello, welcome back to Australian Government and Statutory Interpretation. Week 10, can you believe it? Whoosh. So this week we're going to look at an example of some of the principles that we've been discussing over the last couple of weeks in practice. So we're going to go through step by step and a number of steps and see how the courts go through these steps in practice. Now, most judgments you read, the court won't necessarily systematically go through them all. Some will be assumed, such as reading the actual wording of the statute or considering the jurisdiction. But these preliminary steps that we as practitioners just starting out, these are steps that we need to keep in mind. So I put a list here. When you're reading a statute, you need to ask yourself which provisions are likely to be the most important. So often the action, the verb provisions are what you're looking for because they're authorizing power and the exercise of power. And they may prohibit behavior, for example, or mandate it, as we're going to look at today. So especially where there's been a provision that's been raised for some reason, perhaps it's the provision under which someone's being prosecuted or the order is being sought. So you hone in and focus on that provision and think about, well, how do those provisions relate to other provisions of the Act, particularly provisions just near them? So if you think about the context, step in text, context and purpose that we've been studying, this is all part of the context. All right, so you've got your active provision that's being interpreted, but what's it sitting in and around? What's its contextual situation? The next step is to ask yourself whether any of the words or phrases seem ambiguous or vague, or might have some kind of technical meaning, which could be different from their sort of everyday meaning. So you might need to look at the dictionary, or what's known in the Act as the definitions clause, and see if some of those sorts of terms that make up this active provision are defined in there. And then if you're still not sure about the interpretation of the provision, you're going to need to consider what the purpose of the statute is. There might be some legislative history, so the explanatory memoranda, the second reading speeches, which might shed more light on the purpose of the legislation. And then finally, does the statute raise any issues of interpretive presumptions that we talked about in topic 9? Things like the principle of legality, or a narrow construction of criminal laws, presumption against extraterritoriality that we looked at last week. Where does your we didn't look at that last week, but there's a case, a very good case around weights and measures in Queensland, and yet the product was packaged in New South Wales, and the court in that case had to determine whether the legislation could capture conduct in another state, and they felt it could in that case. So remember, if there are any statutory presumptions or common law presumptions that can be raised, remember though, they can be rebutted. All right, this is a great slide. Love this slide. This could be a poster on your wall because text, context, purpose, right? Within a landscape of common law statutory presumptions within the context of how the Act came about. So just a reminder, focusing on the text in its context and then turning to the purpose of its legislation to make sure that your interpretation of the specific provision, is consistent with that, as required by the AGSI Interpretation Acts and equivalents, remember? And then any presumptions or extrinsic materials. Okay, let's get into it. So the example that's chosen in the textbook is Lupido and Fisher, number 2. And we're going to focus on the judgment of a single judge of the Federal Court handed down in 2019. But it has been subject to a series of decisions. So we'll have a look at those as well and see how it all sort of fits together. Now, the facts behind the case are not entirely clear in the judgments. There seems to be some sort of confidentiality around them. But what we do know is Mr. Lupino, Daniel Lupino, was being investigated for serious offences against Commonwealth law. And he was under surveillance. And his car gets pulled over and searched in 2018. Now, the Australian Federal Police seized 2 Samsung phones. One was being described as being in an OtterBox case, and the other one was described as gold, and then a laptop was there as well. So they've seized all of these items under a warrant, so it's lawful seizure. We'll come to that in a moment. And then under a related provision of the Crimes Act 1914, which is a Commonwealth Crimes Act, they've asked Lupino to give them access to those devices. So he said the Samsung in the OtterBox case didn't require a password, and then he willingly supplied the password to his laptop. But he claimed he didn't have access to the gold Samsung phone. In fact, it wasn't really even his. So he claimed. So the AFP sought an order from Adelaide magistrate Gregory Fisher in August 2018 to order Lupino to unlock the gold Samsung phone. They wanted access, see, to the data and contents of the phone. Now, Lupino continued to refuse, and as the police put it, as he put it, a claim that he was not able to give access. So in December 2018, the AFP went to court again, went to the federal courts seeking an order in the name of an injunction to compel Mr. Lupino to unlock the phone. Justice White of the Federal Court said that the initial order from Magistrate Fisher was not sufficient enough, that there were problems with the definition of various things in the relevant provision of the Crimes Act, which we'll come to in a minute, and he said that the common law privilege against self-incrimination, which is a huge deal, right? So one of these presumptions we looked at in topic 9 is the principle of legality, right? And an aspect of the principle of legality is that your common law rights are going to be upheld. You remember, unless made expressly clear by the legislature that they're meant to be overridden, the presumption is that all common law rights will be upheld by the law. So Justice White said there may be a whole range of information on this gold Samsung phone which might be totally irrelevant to the police's investigation and furthermore could be incriminating. And so Lupino shouldn't have to incriminate himself unless the statute is very clear and the order made under it was very clear. So that's what he had to do. So if you think about it, that's kind of fair, isn't it? If the police are investigating crime X and they want access to your phone and on there is evidence of crime Y and Z, well, it does seem a little unfair that you have to hand over your phone and provide access to evidence that's going to self-incriminate you for those further crimes. You know, it's for the prosecution to gather evidence and prove that, not for you to trip yourself up, as it were, and hand yourself in. So Lupino continued to refuse, and so in 2019, Justice White, so the 18 was the interlocutory hearing, just a brief one, but in 19, Justice White made a full decision on the matter, and he examines the relevant provisions of the Crimes Act, and we'll go through just how he approached that in a moment. And he upheld his earlier ruling and invalidated the Magistrate Fisher's order to unlock the phone. Now, an update is that in March 2021, the AFP appealed this decision to the full federal court, so a panel of 3 federal court judges, and then by a majority, the full federal court overruled Justice White's decision. So this is fascinating because it's all the same statutory provision, and even judges in the federal court have very different views on the correct approach to statutory interpretation. So it's a useful case to teach from because it shows us lots of justifiable ways of approaching the same issue. So we'll have a look at the relevant provisions of the legislation first, but remember we have to focus first initially on the text, and then we'll see what Justice White on the one hand and then the full court on the other hand had to say about context and purpose. So the most relevant provision of the legislation we've got to have a look at is section 3 capital L capital A of the Crimes Act 1914. So it's about someone with knowledge of a computer or a computer system assisting the police in providing access. It says a constable may apply to a magistrate for an order requiring a specified person to provide any information or assistance as reasonably or necessary to allow a constable to do one or more of the following. It talks about accessing the data held in it or accessible from a data storage device. So you can see that it can be including such a device found in the course of a search authorized by a warrant under section 3 capital E, which was the search from Daniel Lupino's car. That was one of those, the 3E. And the order can also compel the person to convert the data into a form intelligible to a constable. So C, section 3LA, subsection C. All right, so they can access it, make a copy, and make sure it's in intelligible form. That's the power mandated or available under section 3 capital L capital A. Okay, so this subsection 2 talks about the magistrate may grant an order if they're satisfied that, well, there's reasonable grounds for suspecting the evidential material is actually held on that data storage device. And the person is reasonably suspected of having committed a certain offence. Then subsection 3. So you can't be vague. You can't just grab a phone and say, oh, I want to see what's in it. You have to have a specific offence in mind that you think has been committed and that there's evidence towards that on the data device or computer or whatever that you're trying to access. It's not just a fishing expedition. We can't be stopped in the street and have to just hand over all our data. You know, think about privacy, think about your rights. Again, this common law right against self-incrimination. That's not the way our criminal justice system works. They can't just go through everything you've got looking for crimes. So, subsection 3 talks about the computer or data storage device that is the subject of the order, and that the order was granted on the basis of an application made before the seizure. So it talks about the time of it having effect. And then there's subsection 4 about the premises, not really applicable here because we're in a car. And subsection 5 person commits an offence, if a person is subject to an order, person's capable of complying, who doesn't do it. Penalty, imprisonment for 5 years, and 300 penalty units, or both. So just to note, at the time of writing, these penalty units, obviously they vary from year to year. They're kind of indexed, as you might imagine. They have increased significantly over the recent years, and currently they're, I think, around a $220 mark. So you do the maths, $220 times 300, and 5 years in jail. So it's a fairly significant penalty. So Mr. Lupino's refusal, as the police saw it, was quite a serious offence in itself, and they were not happy about it. So let's have a look at the Crimes Act section 3C. 3C. Now these are our definitions section in the Act. All right, so we've had looked at an active provision. We're like, tells us a lot of things, but it is using language. So we need to then go back to the definitions section and work out exactly what that language means. So we've got some relevant definitions here. Data is information in any form and any program or part of a program. So that's fairly straightforward. Data held in a computer includes data held in any removable data storage device from time being, held in a computer, or data held in a data storage device on a computer network of which the computer forms a part. So that's pretty straightforward. These definitions, we'll see later, were expanded. So the original Cybercrime Act, which inserted these provisions, 3 capital L capital A, came in 2001. Well, then about a decade later, they're updated to address the situation that the sorts of crimes were being investigated were on network computers, which may not have had the data on them, but in remote tribes or servers or whatever. So the note here, the Crimes Act does not define a computer, which we will see is one of the main issues in this case, because there's no definition of a computer. So this cybercrime bill, which became the Cybercrime Act 2001, introduced by Attorney General Darrell Williams, who was one of the Attorney Generals in the Howard government. And at the time, his second reading speech introducing that bill, the Attorney General said, the bill will enhance the criminal investigation powers in the Crimes Act 1914 and the Customs Act relating to the search, seizure and copying of electronically stored data. The large amounts of data which can be stored on computer drives and disks, and the complex security measures such as encryption and passwords which can be used to protect that information present particular problems for investigators. The proposed enhancement of search and seizure powers will assist law enforcement officers in surmounting those problems. The proposed amendments would clarify that a search warrant can be used to access data that is accessible from but not held on electronic equipment at the search premises. As most business computers are networked to other desktop computers and to central storage computers, it is critical that law enforcement officers executing a search warrant are able to search not only material on computers located on the search premises, but also material accessible from those computers, but actually sort of located elsewhere. So you can see to a certain extent this bill is a product of its time. In 2001, obviously the internet was nothing like we know it today. The World Wide Web had only been up and running for a few years. It was a scientific invention. It wasn't for surfing. It was for sharing research. So it had only really been public for a few years. These kind of networks the Attorney General is talking about in business, where it might be an off-site server, would be about the most advanced situation they'd be investigating. Nothing like cloud servers, remote hosting today, and usually access on devices other than computers now. So this legislation was updated again in 2009. So about a decade later was introduced this bill by Labor Attorney General Robert McClelland. Attorney General in 2009, McClelland said, "Organized crime groups are sophisticated and make full use of rapidly advancing technology. The bill better enables law enforcement agencies to examine and search electronic equipment in an environment where increasingly organized crime is transacted through electronic equipment and over the internet. This ensures that law enforcement officers are able to access data stored on or accessible from electronic equipment that is seized or moved from a warrant premises. New provisions will also allow a magistrate to order a person to provide assistance in accessing the data on a computer or data storage device after it has been seized. This power, which is currently only available when the computer is on the warrant premises, will assist law enforcement officers in overcoming challenges posed by technological developments such as encryption techniques." So they've updated the legislation in 2009, and 2009, just to give you some context, it's about 2 years after the first iPhone came out, and it's about the time of the first iPad. And a couple of years just before this, the first Galaxy S series of Samsung phones came out. There were other phones such as the Windows CE operating system, and mobile phones were becoming increasingly pervasive and used just about by everyone, including people who this provision is trying to address. So the Attorney General also tabled an explanatory memorandum in 2009, which said of subsections 3, capital L, capital A, 3 and 4. So about these orders that can be given currently, when and for how long an assistance order is in force isn't specified. New subsections 3LA, 3 and 4 will together clarify that a constable must obtain separate orders from a magistrate for requiring a person's assistance before and after the seizure of a computer or data storage device. Where an order requiring a person to provide assistance issued before equipment is seized, the order will only be valid until the equipment is seized. If the officer requires additional information or assistance after the equipment is seized, he or she will have to apply to the magistrate for another order. After the equipment has been taken from the warrant premises, if it is necessary to require a separate order to be sought to ensure that the order specifies the time frame in which assistance is to be provided, where it is to be provided, and any other conditions the magistrate considers appropriate. So the idea is that the order from the magistrate should be really specific. And as we'll see, according to Justice White, it should have specified a time frame where assistance is to be provided and other particulars such as, well, exactly what kind of assistance are they demanding of Mr. Lupino, and obviously this becomes one of the issues later. So this explanatory memorandum, it also says the source of the material that an assistance order and apply to will be expanded to include data storage devices, including USB drives and external hard drives, rather than being limited to data held in or accessible from, like a networked computer. This change is necessary to keep pace with changes in technology that allow data to be stored in places other than computers on the premises. So they're trying to broaden the quantity of data storage devices that this Act provision now is applicable to. And that's important to keep up with technological advancements, isn't it? big old computers, clunking great things, taking up a whole room. Then they linked them. So you then want to be able to get the data that's moved to the linked network place. Then there's portable storage devices, isn't there now? We've got USBs. You had floppy disks, but then there's external hard drives. And as we know now, you can send it off up into the cloud and store it. It's not even in your house. So we'll pause there for part 1. And when we come back in part 2, we'll see how Justice White of the Federal Court deals with these issues and definitions. Thanks.